Well, good evening, everyone. Today is Wednesday, June 14th. The time is 6 o'clock, the time designated for this month's public hearing. I'd like to welcome you all to tonight's public hearing. Before we get started, if you could please turn off any cell phones or any other electronic devices to avoid any interruptions. If anyone here is present is planning on presenting testimony, please sign in at the sheet in the back, so we'll have that. Anyway, all three commissioners are present. Madam Clerk, are there any changes to the agenda?
No, they're not.
Okay, the first item on our business is unfinished business. I will accept a motion to remove unfinished business from the table.
Mr. Chairman, I move to remove the unfinished business from the table for consideration.
I second the motion.
Okay, you've heard the motion. All in favor, say aye. Aye.
Aye.
Aye.
Motion carries. Okay, the first item up is application 2022-10624S VAC. I understand this one is to be tabled. Am I correct?
Correct.
Okay, I'll accept a motion to table this application to July 12th.
Mr. Chairman, I move to table application 2022-01624S VAC Engineering Solutions LLP. Table it until July 12th, 2023.
I'll second that.
Okay, you've heard the motion. All in favor, say aye. Aye.
Aye.
Aye.
Motion carries. The next item up is application 2022-02721V, Jake Kinghorn. I understand this application has been withdrawn, is that correct?
Chairman, Commissioners, that's correct. This application has been withdrawn. They resolved the requirement for the variance through a property boundary adjustment.
Okay,
Mr. Chair, I move to remove item number 2, which is 202-202-721-V, Jake Kinghorn from the agenda.
Mr. Chairman, I second the motion.
okay, you've heard the motion. All in favor, say aye. Aye.
Aye.
Aye.
Motion carries. Okay, next item up is application number 2023-00006 VCUMSP, Deanna Butcher. This item was tabled from the May 10th hearing, and it's before us tonight. Now, we didn't close the hearing out, did we?
Yeah, Mr. Chairman, Commissioners, I don't believe this one has been considered at all. Is that
Didn't make consider it at all. All right. So we will then hear from our staff first on this application, and then we'll hear from the applicant. Go ahead.
All right. Chairman, Commissioners, project 2023-00006 VCUMSP is a conditional use and master site plan application for an outdoor-only storage facility and a variance for frontage on a local roadway and a reduction in the required setbacks. The property is located at 8166 South Stewart Road in the Rural Urban Transition District. The proposal includes 40 parking bays that are 15 feet by 75 feet and 108 standard parking bays that are 10 feet by 20 feet. The hours of operation are proposed from 7 a.m. to 11 p.m. Monday through Sunday. County code does require 8 a.m. to 8 p.m. The entrance to the facility would be a shared driveway on the western edge of the property. The applicant would need an easement for this shared access point. The entrance to the facility is proposed to be gated, and the facility would be enclosed and screened by berms. The applicant has stated that the berms would be landscaped, but a detailed landscaping plan was not submitted with the application. There are 2 variance requests before you for this application. The first is to allow the facility to have frontage on a local roadway instead of an arterial roadway as required by Ada County Code. This requirement is a specific use standard for all outdoor storage facilities within Ada County and is intended to keep traffic related to this type of use off of smaller neighborhood streets. South Stewart Road is designated as a local roadway, and based on traffic counts from ACHD in 2019, had average daily trips of 397 per day. The other variance is for the 100-foot setbacks from residential zoned property lines. The property lines affected by this variance are the northern property boundary and the western property boundary. The property to the west is zoned rural urban transition, which is a residential zone. However, with that shared access with those two properties, that does support the need for a reduced setback on that property line. However, the property to the north is zoned as state residential R1, and the facility is approximately 70 feet from the north property line. And the facility could be reduced in size or reconfigured to meet the 100-foot setback from that boundary. The Ada County Highway District did respond to the application, letting us know they do not set level of service standards for local roadways. However, they did not say that they were opposed to the application, and they did provide conditions for if it were to be approved. And these include repairing any deteriorating pavement on Stewart Road, utilizing the existing shared driveway, and complying with their standard conditions of approval. One neighbor did provide comments on the application with concerns about work being done on the property without permits, increased traffic on the residential roadway, and the weeds and proposed landscaping of the berm that was built prior to permits. They did provide some photos, and I've just included a couple of them in this presentation. So you can see the berm, some of the equipment on the property, and the weeds that they had mentioned. Staff concludes that this application does not comply with Ada County Code based on that the variances would grant rights or special privileges that are not otherwise allowed in the RUT district, and that they don't relieve a hardship due to the characteristics of the site. And with that, staff recommends denial of the variance, conditional use, and master site plan. And I'll stand for any questions.
Okay, any questions from the commission?
Mr. Chair,
Yes, go ahead.
do you have an aerial map you can put up so we can look at that? So with regard to encroaching on the 100-foot setback, they're proposing to do that on the north and the west side, or could you?
Chairman, Commissioner Davidson, that's correct. So it's a setback of 100 feet from residential zoned properties. So to the north, there's the road, but then there is a portion that abuts a residential zoned property. That's the R1 property, where the facility is within about 70 feet of that property. The western property, it is a residential zoned property. It doesn't currently have a home on it, and that's where that shared driveway is. So that driveway actually cuts through a small portion of that property. They would need an easement if it were to be approved.
And then can you show me where they're proposing to access off? And, well, first of all, which road are they proposing to access off? Is that Stewart?
That's correct.
And can you use the cursor to kind of show where they want to access from?
Chairman, Commissioner Davidson, the shared driveway is right here off of Stewart Road that cuts through that property line. So the entrance to the facility is farther south on the property line. They utilize that shared drive.
And that's not allowed under our current code because Stewart is what kind of road is it? Non-arterial?
Chairman, Commissioner Davidson, it is designated as a local roadway. So you have arterial, collector, local, and so this is just a local roadway. The code specifically states that storage facilities shall have frontage on an arterial road.
And what's the closest arterial road to the property?
Chairman, Commissioner Davidson, I don't know that. I believe Hubbard is to the south, but it's possible that our director might have a map where he could pull up the closest arterial.
All right, thank you.
I have a question for you. The, what is that property there right to the left of the shared driveway?
Yeah, Chairman, so the property to the west of the shared driveway, there was a contractor's yard that was approved on that property. However, they have not completed all of their conditions of approval to receive final approval of that application that was previously approved. They have notified our office that they don't intend to complete those conditions and use that property in that capacity anymore.
I thought that property looked familiar. And what are those vehicles there, or what are they?
Chairman, from the aerial that's in front of you, it does appear that there are vehicles there. I believe that there may have been a code enforcement case on that property as well for utilizing it prior to approval.
Yeah, because it was approved, it was given conditional approval for contract yard. But we put some restrictions on it, and they haven't been complied with at all.
Chairman, that's correct. There are landscaping requirements that were required as a condition of approval, and those haven't been met. So there are improvements for that project that were not met. And from our understanding, the applicant has notified us on that property, not the one we're currently discussing, that they're not going to be utilizing it in that capacity anymore.
Does the applicant own both properties?
Chairman, the properties are owned by different people.
Okay.
Mr. Chair,
Yeah.
the neighbor who sent some comments in, is his property visible on this map?
Chairman, Commissioner Davidson, I'm not aware of where that property owner is located.
Okay.
Okay,
Mr. Chairman.
go ahead.
So right now you said Stewart is a local roadway,
Chairman, Commissioner Daly, that's correct. It's designated as a local roadway.
and how does it become an arterial?
Chairman, Commissioner Daly, roadway designations come from the Ada County Highway District, and they come from the capacity and size of the road. So we're talking about how much traffic is on the roads, how much they expect it to be used. So local roadways tend to be your neighborhood roads where your residential properties are largely at.
And you said like it was 327 trips a day. Was that still not an arterial then? What's the level of?
Chairman, Commissioner Daly, I don't know exactly what is required for a road to be designated arterial, collector, or local. The Ada County Highway District sets those designations. So based on those trips from 2019, this is not an arterial road.
And did the Ada County Highway District, their comments, how comprehensive were they in terms of the kind of stuff I'm just talking about?
Chairman, Commissioner Daly, they went into their conditions of approval, their access points. They don't set level of service standards for local roadways. So with your arterials or collectors, they're going to tell you if it's meeting the needs of the road and the traffic. But because it's a local roadway, they don't look at that. So they just have that trip count from 2019 as a data point that they provided. They did provide conditions of approval that they would want if you were to approve it, but that's pretty much what they provided.
What were those conditions?
Yeah, I can go to the slide. So it was to repair any pavement that may be deteriorating or deficient along Stewart Road, no permanent structures within the 30 feet of the future collector roadway, which there is a future collector that they're saying along the southern portion of the property. There's not a road there right now, but they're saying in the future they foresee a road being built there. They want them to use the existing 30-foot paved shared driveway, which is what they're proposing, that there may be a traffic impact fee, and that they need to submit civil plans to ACHD Development Services for review and approval, and then comply with their standard conditions of approval.
So they're saying the road on the south, looking at this map again, there isn't a road there now, but they're saying they envision there being an arterial road on the south end of the property, but not the north end?
Chairman, Commissioner Daly, they actually are saying that they foresee a collector roadway, which is actually still a designation down from an arterial.
Okay. Even though there's not even a road there now?
That's correct. They do plan for roads in the future, so they let people know what their plans are and where they think there might be roads as development occurs, but there is no road in there currently.
It's interesting. They made a comment on a place where there's not a road, but not on a comment where there is a road. I mean, Stewart is a local road, so they don't comment on it. And where there isn't a road, they made a comment on it that it's going to be. That's an interesting.
Chairman, Commissioner Daley, they did comment on the application addressing Stewart Road and what they would want if this is approved, and how many trips that they count. But on local roadways, they don't have level of service standards, and that's across all local roadways. So they did provide comments to what they have available.
Yeah, Mr. Chairman, Commissioners, the Highway District does rely on an adopted functional classification map that designates which roads are collectors and arterials. So, in this case, they have a future designation. They envision a future connection, essentially extending Hubbard across the south of this piece, connecting over to Cloverdale, I guess it is. And to
That
answer,
would, excuse me, that would be Hubbard on the south then.
yeah, the very bottom left corner, Hubbard bends around and I guess turns into what would be Stewart there. It's a collector road there. The nearest arterial road is to the north. If you followed Stewart up off the map to the north, you'd hit Columbia, which is the nearest arterial road. But yeah, there's a functional classification map. That's what we would rely on as well, that designates what is an arterial and what is a collector road.
Another question for staff. So the right-of-way, they said that there is or isn't a current right-of-way agreed to on the entrance to the property that we're talking about? There is a right-of-way that's being used?
Chairman, Commissioner Daley, that access point for the shared driveway where it connects to Stewart Road was approved by the Ada County Highway District. There is not an easement for the portion of the road that crosses into the neighboring property that I'm aware of or that was submitted with the application. That might be a question for the applicant. I do believe that they know the property owner, and so you might want to ask them about that. But we would require an easement if you were to approve this application for that shared driveway.
And that was my next question. Okay, thank you.
Mr. Chair,
Yes, go ahead.
under our code, does it require a 100-foot setback around all four corners?
Chairman, Commissioner Davidson, the requirement is actually a setback from residential zoned properties. You will see that there are homes on the properties to the east, but those properties actually fall within our rural-based districts, and so they don't have that residential zoning designation. So the 100-foot setback is not applicable to those property lines.
Where would it be applicable?
Chairman, the residential zone properties are the property to the north and then the property to the west where that shared driveway is. Those are the residential zone properties that surround the subject property.
The west, that was going to be a construction yard?
That's correct. It is residentially zoned. It's the rural urban transition district, which falls into our residential zoning districts.
What type of storage facility are these, are the people planning here?
It's an outdoor-only storage facility, so generally we see recreational vehicles as the main thing that's parked in those.
Okay.
Just to clarify, they're not proposing to build any structures. It's parking RVs or similar things.
Chairman, Commissioner Davidson, that's correct. There are no structures proposed with this application.
Okay. Any other questions from the commission?
Not at this time.
Okay, thank you. We'll now hear from Deanna Butcher. Hi, Deanna. You got 15 minutes if you want.
So we own a farm, and we had the National Soil Conservation come out, and because we're trying to become organic, and so we were looking at what was viable land. The north section of our property is all lava bed, and it's pretty much just dirt. There's no actual soil there, so it's pretty devoid of any organic matter. So in order to plant, it would have been very, very expensive to truck in, really nice dirt.
Could you hold on just a moment?
Amend
Could you put the aerial up again so as she's talking about, we can get an
Sorry.
idea? No, that's not your fault.
My apologies.
No, that's not your fault. Go ahead. There, now we can see. Go ahead.
We're talking about this parcel that you're
Yeah.
meant to be a farm.
You're the applicant.
Yeah,
Okay.
she's the applicant. Sorry. Yeah, go ahead.
So, and then coupled with that, my husband got sick last year, and with medical bills and stuff like that, we were like, okay, well, how can we make some passive income to kind of offset that and use this property, this north end, since we can't really use it for our farm, it's unfarmable. So we're talking to friends, and they said, you know, we've got trailers and stuff that we need parked. Plus, there's a lot of developing going on in Cuna Meridian area, so you might want to look into that. So we were like, okay, let's get that situation. Let's see what we have to do in order to get that done. The property to the west is my mother-in-law's property. It's in a trust for my husband and my family, and so when she passes, that property would go to us.
The one that they had approval for a construction yard there.
Correct. She decided to move because her ex-husband lives in the property to the west of that property and was harassing her. And there is actually a lawsuit going on because of all that. So she decided to move the business because of all the harassment and decided she got a shop somewhere else in Southeast Boise.
Okay.
Yeah, we share the property. We lease the southern part of her property for farmland, and she could care less what we do in reason with that property. So,
Okay.
yeah. I'm a horticulture student at CWI, so we decided that we would do hugel berms. That's what you see surrounding the property as we speak. So my husband's family owns a tree removal, tree trimming company. They actually hold the Boise City contracts. They do a lot of the major removals and stuff like that. Prior to us living on the property, there was a bunch of felled tree logs and stuff that his parents would store on the property. So it was literally just a junkyard for a bunch of logs. It's a horticulture practice where you can take these felled logs and you stack them, and then you put slash, and then you cover them with dirt, and it actually makes that those berms viable once they decompose after about 3 to 5 years. And we were like, okay, well, that would be a solution to actually plant something around the property and make it pretty. So as of right now, it's only a year old, but our plan is to be able to plant something on those berms and make it actually really pretty.
Okay. Where's your farm? You said you have some farm.
Yeah, so my house is the black house on the south side of the property. Our north pasture is about 4.5 acres. It's that greenish, I mean, it's a terrible picture, but it's the greenish portion right above that black house. And we have Highland cows and chickens that we raise. And we do permaculture farming techniques. And like I said, we're going through processes to make it organic. It takes a little bit, but we're working with the NRCS with that.
So how are you going to do that if you're parking some or leasing some space for motor homes to park and
Sure.
trailers to
So
trailer?
there's actually a berm that separates the. There's a square there, and I think that was dirt from previous stuff that before we owned the property. I think his ex-father had done. That's gone now, but there's a berm that goes on the south end there, and it's 13 feet taller than our actual pasture, and so it's not even visible from like our view where we're sitting, where our house is. So our pasture actually sits quite a bit lower than the actual topography of where the parking area is.
Is that where the picture that showed the berm? Is that the berm you're talking about?
That would be the north berm, because I'm looking at my house, and so that's from the Stewart Road.
That's from Stewart Road.
That's from Stewart Road, yes,
So
sir.
so the house in the picture, in the lower picture, that's your house.
That's my house, yes, sir.
Okay. Huh. That looks like quite a big pile of dirt.
It is. But we plan to make it, we wanted it secluded, and it's not like anyone wants to see trailers or ATVs, so we figured landscaping and having that privacy would be a courtesy for our neighbors. And most of them we have talked to, and most of them that I know of do not oppose that idea, except for this one that I'm hearing about. So don't know who he is, but we'd be glad to talk to him about it.
Okay, could you go back to the aerial there? I want to. Okay, there we go. Well, this aerial looks a lot different than the picture we just saw.
Yeah, I think it's much older than, I mean, because, yeah, it's got to be at least 9 months, because like I said, that square is gone now. That's in the middle section
The
there.
white square, what is that white square there?
I have no idea. I don't know if, I have no idea. Like I said, he used it as a slash pile for a while, so I'm assuming there's a bunch of debris and stuff because we've moved most of that since then. And there's no trucks and stuff, like I said, being parked in the other property either. Like all those trucks were, when she got her contractor's law approval or pre-approval, those were her work trucks that she was parking on the property. But they're since gone.
So none of those vehicles are there now.
No, sir.
And that property is owned by
My mother-in-law.
your husband's mother? Mm-hmm. And she's abandoned it or left the property.
She still owns it. It's in the trust. It's in a trust for our family. Yes, but she's since abandoned it because the gentleman to the northwest corner of that property is my ex-father-in-law and his new girlfriend, and they've been harassing her.
Oh, okay, well,
Yeah, so she's on to bigger and better things.
all right. And it's that property that's causing the problem. Is that not correct?
Chairman, there are two property lines that the facility is within 100 feet of. The western property line that you're mentioning, and then the northern property line
The northern property line up north there.
in the northeast corner.
The majority of it is the street. And then there's that little corner there, is that the offending lines?
Chairman, that's correct.
Okay.
I actually know that gentleman. I know that neighbor well, and that's a weedy pasture. He doesn't even irrigate because it's too tough for him to do anything with. And he's a great guy. Like, we talk bees.
And you said the northern part of your property there is all just lava rock, pretty much.
Yes, sir.
It's not tillable soil.
No.
And that's where you want to park the vehicles?
Yes, sir.
Okay. And that berm we saw on the other picture, where is that in relation to this picture?
Okay, so you can see the red property line, and then
Yeah.
you see kind of that a shaded line that's a bit crooked. That is a berm. So you see these shaded lines on the outside. Those were the workings of our berms.
Those are the berms right there.
Yes, sir.
Okay.
And they're about 40 feet off of the actual road.
And this road that comes down here, that's your access to your home, right?
Yes, sir.
Okay, and it's just like a gravel road or something?
Yes. Pit run, I think. Yeah.
Yeah, all right.
And that, back to my previous question to the staff, the easement is not a problem because it's your mother-in-law,
Yes, sir.
and you use it now for your house.
Yes, sir.
Okay. All right. You have anything else?
No.
One more question. So, this is staff as well as you. So, just to recap in my understanding, the only offending edge of the property is that northeast corner with that other property, right? Because you have the right up there. That's the offending property line easement, or too close to the boundary question, correct?
Chairman, Commissioner Daly, the variance is for the northern and western property line. However, as we've discussed, they do have that shared driveway, so that kind of supports the request for the variance on that property line. And then, yes, the northern property line, where the facility is within 100 feet of that property.
Is it the entire northern line or just the corner?
Just that.
Just where it abuts the residential property.
So is the property to the left of the road, is that also residential or just to the right of the road? the road going up and down.
Chairman, Commissioner Davidson, if you're talking about the property line along the road, because it abuts the road, we don't consider that abutting residential, so there wouldn't be a 100-foot setback there. Where my cursor is now currently, this property line abutting the residential property to the north is where that 100-foot setback encroachment is.
Okay.
And that's where part of the current berm is, correct?
Correct.
And that's about, what, 15 feet high? It's pretty high there.
Yes, and 45 feet wide.
Yeah. And how far off the road is that berm?
40 feet.
40 feet?
Yes, we already talked to ACHD when we were putting in our shared driveway, and they had said that from the median of the road, that anything that we were placing there, it would be safe to say that 35 feet was appropriate, and so we just made it 40 just to be extra safe, and we started our berms at 40.
So from that little line, if you'd go 60 feet down there, you'd be in compliance, right?
Most.
60 feet from the berm.
Chairman, are you saying from the berm into,
If the berm was 40 feet off and they went 60 feet from that berm and didn't park any mobile home trailers in there, they'd be in compliance.
Chairman, potentially, we do, the code does say, I believe, from the boundary has to be for the facility. So if there's a drive aisle there, we would consider that to be part of the facility. So, that's where our findings came from.
But if they designed it, back to the chairman's question, if they designed it so it would be that 100 feet, then it would be in compliance.
Chairman, Commissioner Daly, that's correct. As I stated in my presentation, they could reconfigure the facility to meet that 100-foot setback.
Okay. Anything else?
No, sir.
Okay, thank you. Is there anyone else that has any debate or any comment or any testimony on this application? Okay, hearing none, I'll close the application.
Oh, Mr. Chair, before you do that, did staff have the letter or email comments from anyone else commenting on this?
Chairman, Commissioner Davidson, there was a late exhibit that was provided to you, and those were the comments that were included in the presentation. There were no other comments that were submitted to me.
Can you summarize the comments one more time?
Yes, so they were concerned about the utilization of the local roadway. They were concerned about the weeds and the ability of the applicant to be able to landscape the berms. Excuse me. And that there was work done on the property prior to permits. And that the 100-foot setback should have to be met. That was also included in those comments.
Mr. Chairman, I have another question for her, if that's appropriate, or you already closed the hearing?
No, I'm closed hearing. Go ahead. If you have any
I have
questions
another
there.
question for you, ma'am, if you. You indicated you're a horticulture student?
Yes, sir.
So, and the berm you said was going to be designed so that it would have vegetation, et cetera?
So it could sustain vegetation, yes.
So what's the concept of that in terms of watering it, for example?
Yeah, so we actually have a pond that we've dug for, like with the NRCS. It will be a reservoir, and we will pump along the edge of those berms. And that's how we'll water the berms and irrigate them, once every 10 days. We
So-
have, sorry.
Go ahead.
We have water rights to 2 separate canals. And so we actually get more water than most on our property. We're very fortunate that way. And so we can, instead of having rights like 6 days out of the month, we can water almost every 3 days if we wanted to.
Because of the lava flow, you have it on acreage, and you can't irrigate some of it because it's not.
Right, it's not irrigatable, but yes, the berms are.
So would you be amenable to configuring it differently than what your proposal was to address the 100?
We can scoot it back a bit. It would take some equipment, which is moving dirt, which if he's opposed to that,
Not necessarily moving the berm based on what she said, it's just making sure the facility itself doesn't. Am I correct in what you just said?
Chair-
Just making sure the facility doesn't utilize any space within the 100 feet, correct?
Chairman, Commissioner Daly, I can bring up the site
Right here.
plan.
so we don't use the 100 feet on the west side of the property line. As you see, we start the stalls in the middle. And then we have within the 100 feet, because it's, like I said, 45 feet and then another 40 feet from the roadway. And then we calculated it on a CAD, but the set line where these large stalls are going to be placed is about 15 feet from the start of the berm. So we placed them within that 100 foot. So yes, they won't be within the 100 feet.
It
of
looks
that
to me like,
north.
looks to me like a couple of your stalls would be, if you moved a couple of those stalls there on the east side of it, then your facility would be within the 100 feet.
Okay,
That's what it looks like to me. Am I right?
completely do that.
Chairman, based on my measurements using our GIS mapping system, that's correct. That portion where those stalls are located would be within 100 feet of that property boundary.
So if like two stalls were moved, looks like two to me,
2, 3 at the most.
three at the most, then it would be in compliance.
Chairman, our code does say the boundary of the facility. My interpretation as staff was that anything within the berm was the boundary of the facility. It would be up to you if you do choose to approve this, how you condition it, and if you want to do it that way, you could.
Okay, well, thank you.
Chair?
Yeah.
So you're proposing 7 a.m. to 11 p.m., 7 days a week?
We didn't know the ordinances, we would abide by the ordinances. So if it's 8 to 8 or 8 to 7, we would abide by those rules.
What kind of traffic do you anticipate coming in?
There's actually already pretty heavy traffic. There's, like I said, my ex-father-in-law owns a tree trimming and tree removal company called Two Rivers, and he's got big semis and loaders and all sorts of stuff coming in and out of that road. There's also several farmers, and we use that all the time for our equipment as well. So I don't know, adequate, I think it would be. There's soccer tournaments at the Hubbard Reservoir area there, so there's quite a bit of traffic during those tournaments as well on Stewart Road. So I wouldn't imagine it would be anything more than what's already happening, maybe a smidgen more, but.
My only concern is if, in a couple of years, there's new development that comes close by, and if they feel that, they want that setback, and then maybe it is infringing on them. Or if, a better road is built in the future, that would be more appropriate for people to enter on there. As they were discussing, there may be some roads nearby in the future. Would you be amenable to, maybe we put a review on this in 2 years, where you come back and we see, okay, they've built a better road. This be better in the public's interest if you entered from this road. Is that something you'd be okay with if we put it?
Of course, yes. I do know that the proposed road to the south that hasn't been developed yet is on the south property line abutting our property. And that road has already been contested by both of our neighbors that are on that south property line pretty heavily. And then Ada County came back, according to my neighbor, and saying that they were no longer kind of considering that road because of how much flack they were getting from those neighbors. Because one neighbor owns 17 acres, plus you can't develop under 5 acres in that area, one house for every 5 acres. And then the other one is a farmer named Mike Bishop, and he too was contesting it because it would make him move his shop because it was literally within where his shop is, in line with where his entrance of his shop is. And so he would have to move his barn and his shop all together. So I don't think that road, as of right now, I don't know how feasible that road will be to be placed there. But yes, we would work with you guys.
Okay, thank you.
Thanks.
Chairman, Commissioners, I would, this has been coming up a lot because we've been adding these review conditions to different projects. And staff we'd like to ask for clarification on those conditions so that we can spell it out in the condition of approval in terms of, again, and this is if you go that direction, who the reviewing body will be, how we will conduct notification for that review. So are we doing our standard radius notice, site posting, things like that? And then whether or not we're going to schedule it for a public hearing. So I guess just things to think about if you want to include conditions like that, because staff has got a few of these existing projects out there with that condition language that doesn't have it very well spelled out for us. And so we are getting questions from the public or the applicant as to how's this review going to work? How are we going to put that together? So yeah, just think about the nuts and bolts of that as you consider a condition like that.
We'll consider that if we go that direction. I'm a little like you. I don't know if we ought to keep adding much review time. That's what we're doing now, but anyway. Anyway, yeah, we will consider that. If there's any other questions, then we will close the public hearing on the application. So let me get it there. We'll close public hearing on application 2023-006-V-CU-MSP. Public hearing being closed. It's now up to the commission for discussion. Anybody want to kick it off, or you want me to?
I guess I could kick it off. So just as a reminder, the applicant's requesting two variances. One is to encroach on that 100-foot setback in the north corner and on the west side, and then also to be able to access the property from the local road, Stewart Road. So we need to address those both specifically. I guess other issues that came up, the landscaping, they haven't submitted a landscape plan, so I guess we need to decide if we want to require that or not. And then, if we wanted to put an additional condition in maybe a couple of years in the future that they come back in case there's a new road built or new development around there that these may be encroaching upon. I like the fact that they're not building any structures, so that means there's some flexibility there. We're not going to have them build something and then tear it down in the future. But it's basically a parking lot, so it could be adjusted in the future if needed. I don't see a lot of problem with the western boundary. I mean, again, their family owns the other lot, and there's, again, nothing really there. The northern boundary, it seemed to be a pretty minimal intrusion if they were to be granted that variance. I can't see that infringing on the neighbor to the north, especially if the berm were there and to be kept watered and manicured. As far as the variance for the road, I haven't heard a lot of evidence that there would be a lot of potential harm with the extra traffic. It sounds like there's already a fair number of cars going down there. Obviously, I was concerned about the hours, and if traffic got to be an issue, I suppose we could always put a restriction on there on the hours of operation, maybe limit it to a smaller time period than 12 hours a day, 7 days a week. But those are the things that I'm looking at.
Okay, any other discussion?
No, I think you pretty well summarized it in terms of, I think we just need to look at if we want to approve it, what kind of conditions we put on the approval.
Okay,
So that there's more specificity in terms of how they would use it.
right.
It's basically the property is not usable for what it was originally designed, and that's agriculture.
No, it's not even usable for agriculture, at least not
That portion.
Not that portion of it, and there's a house, there's a house there. I think I would be fine with granting the conditional use permit if the applicant would adjust their plan there so that they're not butting up against, so that they comply with the 100-foot, even though staff says it's for the whole facility. I think the intent would be for the actual utility of the facility. And so and then if we put a further restriction on that they give us a landscape plan, give staff a landscape plan around the berms there, and when they can have it done and so forth, then I'd support the conditional use permit if we put those restrictions on it.
I would agree with those restrictions. I was going to go there as well, that northern corner is accommodated appropriately. And I agree with you that the intent is the usable space, not necessarily the berm, but the usable space. And that as long as that condition's on there, that's their understanding as well. They can move the berm if they want, but it's the usable, what they use the space for, within 100 feet.
Well, I think so. I think that'd make it fairly simple. We could draft up a revised findings of fact and conclusions, and if we make that the findings of fact and conclusions, that they have to give us a new site plan that would accommodate the 100-foot from the zoning there. I don't think it matters on the west side because it's a family thing and it's not really being used as residential anyway, that portion of it.
So what you're saying is the berm would be within 100 feet, but the RVs being parked would be outside the 100 feet.
Right,
Exactly.
right.
I don't think the berm matters where that is, other than it's designed as a barrier.
Right.
But that doesn't mean that's where the parking will be. And so if the parking is within the 100 feet and then landscape the berm, I think that would be fine. One of the things we do here is we anticipate, if we think there's going to be problems with future highways and so forth, then we should make that decision here, not in 2 or 3 years. But I think we should do this right the way it is right now. I'd be fine with that if somebody wants to make a motion.
Okay.
Well, the only thing I was thinking of is if ACHD builds a more appropriate road in the future, and the local road, if it ends up getting too much traffic as a result of this, then we could require them to modify it to enter off the more appropriate road.
That'd be up to ACHD at the time, wouldn't it?
That's correct, Mr.
Yeah,
Chair.
that's an ACHD
That'd be an ACHD issue.
decision, right?
Okay, I'll accept the motion.
Okay, I move that is staff clear about do you have any questions regarding what our discussion was in terms of the conditions?
So, Mr. Chairman, I guess I'll speak and I'll let Corey chime in as well. So it sounds like you're going in the direction of approving this request, the variance request. We could either.
With conditions.
With conditions. We could either.
With the condition that their plan be changed to accommodate the 100 feet from the corner there, that their site plan be changed, they don't park their stuff within 100 feet, and that they produce a landscaping plan for the berms.
Yeah, Mr. Chairman, I guess my question is, do you want to be able to review those documents or just have those submitted to staff as conditions?
Submitted to staff for
Okay,
conditions.
so I think that'll probably give Corey enough information. She can draft findings for you to review at the
Right.
next public hearing, which would
Right.
be July 12th. And we could have those back for you to review and approve at that time.
Okay, so the motion would be to table this until July 12th with the conditions that the staff would prepare a
Well,
finding.
Mr. Chairman, you could move to approve and
Right.
table for revised findings. Yeah, that could be an appropriate motion if you so choose.
Okay,
Okay, I so move that we table it until July 12th for revised findings of fact, correct?
And approve?
And approve. Approve it.
with the revived findings of fact and conclusions of law.
And I want to make sure our clerk is,
Do you understand the motion?
Okay, so I'm hearing you to say that you're gonna approve the application.
Correct.
We're tabling it for revised findings of fact and conclusions of law to
July.
July 12th,
Correct.
public hearing? Is that
public
correct?
hearing.
Okay,
And does that include adopting ACHD's requirements?
No.
Yeah, Mr. Chairman, Corey could add whatever the typical condition would be for ACHG requirements. We can certainly draft something up for you to review.
I'll second that.
Okay, we got a second? Is it clear now? Okay. All right. You've heard the motion. All in favor, say aye. Aye.
Aye.
Right?
Motion carries. Okay. That was a little more complicated than we thought it was gonna be. All right. We're still under old business. I'll open the public hearing on application 2023-00502 ZOA, Ada County Development Services. I don't know about this one.
Yes, Chairman, Commissioners, thank you. So this is a zoning code text amendment specific to Title 8, and Ada County Development Services is the applicant on this one. The purpose of the text amendment is to amend portions of Ada County Code Section 8-2D for specific to the industrial-based districts. The amendments are focused on clarifying various sections of the code to allow for industrial-based districts and uses to be located outside of areas of city impact on a limited basis. Just to note, we do have some of this zoning outside of areas of city impact, but staff and based on some recent projects and requests by applicants feels that this amendment would better clarify things for future applications, the public, and obviously the county as well. So, oh, and I need to share my screen. Sorry. That always happens. It's not a very exciting presentation, so you guys weren't missing much, but, all right. So, next slide is the first section that we would amend, which is the purpose statement for 82D-1. And again, I'm not going to read it verbatim, but basically, we want to focus on enabling our comprehensive plan, implementation of our comprehensive plan, which actually does call for these types of uses in areas outside of city impact. And so this amendment would actually better sync up our comprehensive plan and the zoning code to accommodate kind of that goal of the comp plan, but also to do it in a responsible way and limit it on a case-by-case basis and allow us to take a very close review of each request and each property and consider it in its own merits. And so that gets us to this section, which we're adding item E here that specifically asks us to look at this table of allowed uses and to consider those uses that are typically principally permitted to be conditional if they're in an area, on a property outside of an area of city impact. Now, not across the board are all of the principal uses now conditional because there actually are some overlaps in specifically like the rural district and the industrial district where both were permitted, and so we've allowed those to both remain permitted. But it's typically any situation where the use didn't appear in a rural-based district because that's the majority of our land outside of areas of city impact. If it didn't appear there, then we're now saying that's going to be a conditional use permit. And so I've got a link to that document. Let's hope it still works for you guys. It's this table here. And what you'll see, if I can zoom in here a little bit for everyone, is we have now this little footnote here. So typically this use is permitted in the M1 district. However, with this footnote, it says if you're attempting to put this zoning on a property outside an area of city impact, that principally permitted use is now going to go through a conditional use permit process. And so realistically, any of these requests would probably have a zone change attached to them anyways, so we would be considering them at a public hearing, but this just further ensures that we get to consider those conditional use permit findings, which, again, look at things like compliance with the comprehensive plan, mitigating impacts on neighboring properties, compatibility with neighboring properties, different things like that. So it's, again, one more lens that we can put on the request for this type of zoning and those types of uses. And I won't bore you with walking through every single table or every single use, but part of the motivation for this amendment is that we actually have some areas of the very rural part of the county that makes sense for industrial uses, namely the railroad portion that crosses through much of the unincorporated area outside of city impact, and we're starting to see some requests for uses popping up along that rail line. And also, a lot of the, some of the use requests just wouldn't be appropriate for an area of city impact. They're of such a industrial nature that we wouldn't want to put those in an area that's going to grow and develop around, for example, a future sawmill or something to that effect. So let me go back to the presentation here. Hopefully, if I can figure out how to get back there. So we received no comments from the public on this application, and any comments that were received from our partner agencies and jurisdictions were either not opposed or stated that they supported the amendment. The city of Boise did ask for a little bit of extra time to consider our request, but no additional comments were ever received from them. So as it goes, if we don't hear from you, it usually means you're okay with it. So to that point, staff is recommending approval of this text amendment, and it should be noted that the Planning and Zoning Commission recommended unanimous approval at their public hearing. So stand for any questions.
Okay, are there any questions?
Mr. Chair, so we discussed previously that, maybe in the future, this could also be extended to commercial or residential developments that may want to develop outside an area of city impact, but we're starting with industrial because that's appropriate. Ada County would like to keep industrial further away from cities, but we could at some point expand that to commercial.
Yeah, Chairman Commissioner, yes, we are considering expanding this to the commercial district. That would be a new application brought before both the P&Z and this board. Go through a similar process of notifying everyone, fielding comments from the public, and so forth. But yes, and to that point, we have existing commercial zoning outside of areas of city impact already. So again, another opportunity for us to kind of better sync up our zoning code with the vision and goals of our comprehensive plan and what's actually occurring out in the unincorporated areas. So.
Is there any concern that putting this additional language in, sort of clarifying, could affect previous decisions we've made because we were relying on different language or contradictory language?
Yeah, Chairman Commissioner, I don't think so. I mean, again, I think the point of this text amendment, that those requests have already been made. They've already been approved in multiple areas. This text amendment is really just to make it clear for everyone involved in the process what the point of this is. I don't think I think it could be argued that those rights existed before, and again, proven by the rezones that have occurred. This, again, just better clarifies how we should handle future requests like that. For people who participated in public hearings recently, there was a lot of back and forth about whether or not that was an appropriate thing to do. The point of this text amendment is just to really clear it up for everyone that, we were already doing that and we're going to continue doing that, and this is the way that we would move forward. So,
I guess some might question, well, if you're doing it already, was it illegal without this text amendment? Like, how did we do it before this text amendment?
yeah.
Kind of fly by the seat of our
Chairman
pants.
Commissioner, I would say that the code in place now allowed you to do it, and the board made the decision to do that. I think there was, it's always up to the county to interpret its own code and make decisions based on that interpretation. We're just trying to maybe spell out the rules a little bit easier for everyone to follow. But it's always at the discretion of the board to make those decisions, and this board and previous boards have done that in the past. So,
With other zones, like commercial.
yeah, commercial, we've had some additional industrial in different areas. There aren't a lot of examples, but there are some examples out there.
RV park.
Yep, that's one.
It just reinforces.
Yeah, I think again, to staff's point, provides clarity, and it also, I think, creates protection for the community and for the property owners to understand how do we go through this process, what are the things that have to be considered. I think the layering on of the conditional use permit is a thing that gives that next level of assurance for everyone that not only are we looking at the zoning, we're going to look at impacts on neighboring properties and compatibility with the neighboring properties and that sort of thing. So it's like one extra layer.
Okay. Would the applicant like to issue comments?
The applicant will rest on this.
All right, we'll close the public hearing on application number 2023-00502, ZOA, Ada County Development Services. There was no other comment.
I mean, I guess you could technically ask the public if they have any comments. I don't know if we did that. but-
Okay, we can open the public hearing again if we need any more public comment. Is there anybody who wants to comment on it?
Yes.
I didn't get any sheets here that anybody wanted to comment on. We don't have any online, so,
Mr. Chairman,
yeah.
are you available for a motion?
Yes, I'll accept a motion.
Okay, I move to accept application, or 20230050 ZOA Ada County Development Services rezoning ordinance application. I move that we
That
accept.
would be to approve the application.
Approve the application.
Okay, is there a second to the motion?
Second.
Okay, any further discussion? Hearing no further discussion, all in favor say aye.
Aye.
Motion carries.
Okay, thank you.
All right, now we're getting into new business. I will open the public hearing on application 2023-00186, SVAC Centurion Engineering. We'll take a few minutes from the staff.
Mr. Chairman?
Yeah.
I declare a conflict of interest pursuant to Idaho Code 676506 and recuse myself from discussions, deliberations, and vote on this application.
Okay. Duly noted. You don't have to leave, but you can be here. Oh, you do? Is that what it says? Oh, I didn't know that. Okay. Well, just be outside because you can come back in. We got another application going on. Okay, go ahead, staff.
Chairman Commissioner Davidson, project 2023-00186 S-BAC is a preliminary plat for a two-lot subdivision and a vacation of a public utility irrigation and drainage easement. The properties are located at 11052 West Rutzel Drive and 3976 South Genesee Drive in the R2 low-density residential district and contain a total of 0.96 acres. The original lots were platted in 1974 with 5 Mile Estates West subdivision number 3 and number 4. The property addressed 3976 South Genesee Drive was originally platted as a well lot, restricting it from development and allowing for the smaller size of 0.21 acres. An administrative property boundary adjustment to increase the lot size is outside of substantial conformance to that original preliminary plat, which is why a subdivision application is required. The subdivision will result in 2 lots within the R2 district, which the minimum property size is 16,000 square feet. Lot 1 will be 19,000 square feet or 0.44 acres, and Lot 2 will be 22,500 square feet or 0.52 acres. The existing structures are to remain on the site, and sewer and water services are available to both lots. The applicant has requested that a public utility irrigation and drainage easement be vacated, and you can see that easement shown on the screen here in yellow. All utility holders have provided written approval of the vacation, and as conditioned, the applicant shall provide the same approval from the irrigation district. There were no agency objections to the application, and no additional improvements are required by the highway district. 2 letters were submitted by neighbors with concerns about privacy, noise, traffic, and lot size. And the Planning and Zoning Commission and staff are recommending approval of the preliminary plat and vacation, and I'll stand for any questions.
Okay, any questions?
Not at this moment.
Okay, I don't have any questions. Is the applicant here? Okay. Go ahead, you got 15 minutes.
Okay, I won't take that long, I promise. Thank you, Chairman Beck and Commissioner Davidson, and many thanks to your staff as well. I know every applicant says how great staff is to work with, but you should know that your staff is kind of setting the bar as far as being public servants throughout the valley. They answer phone calls, which is unusual these days. In addition to just being great for folks to work with, I really have enjoyed working with them lately. My name is Anna Canning. I work for Centurion Engineers. Our address is 2323 South Vista, Suite 206 here in Boise. And tonight I'm representing Michael and Peggy Sue Lott in their request to approve this two-lot subdivision and to vacate easements on the existing lots in order to move forward with the new subdivision. Ms. Bending's staff report does a great job of addressing all the facts and findings related to the project. It's the one unusual circumstance is that the owners do have two recorded lots, but we have to do a subdivision to create the two new lots, and there's just a quirk in the Ada County Code, which is fine. I don't know if you know, but I actually wrote that little bit, so I get teased for it a lot. But it was there for a reason 23 years ago. I support any text changes you want to do at this point. The existing residential lot will be relatively unchanged, other than losing some of the backyard, and the existing well lot will become a new residential lot. Normally, an owner would be able to do that through property boundary adjustment, but not in this case. During Ms. Bending's presentation, you may have thought, wow, this looks like it should be this way. Why isn't this way? It really is seamlessly can go into the neighborhood. The two proposed lots are the same general width, the same general length, the same overall area as the surrounding properties on Genesee Drive and on the north side of Ritzel Drive. The new residence, once constructed, will take access from Genesee. There's no flag lot, no common lot, no private street, nothing like that. It's just a straight driveway out onto Genesee. So it really is seamlessly fitting into the neighborhood. So in summary, we've obtained all the necessary relinquishments and for the existing lots to move forward with the final plat. And the proposed lots meet all of Ada County Code requirements for density and dimensional standards. And the existing infrastructure has sufficient water, sewer, and roadway capacities to support the additional home. With that, we respectfully ask for your approval on these two applications, and I'll be happy to answer any questions you may have.
Okay, are there any questions? Do you have any questions, Commissioner?
I don't think so.
No, I don't have any questions. Thank you. Thank you. We have two people who have signed up to testify on this. Tom Bridges,
Yes, sir.
all yours. You got 3 minutes.
My name is Tom Bridges, 3930 South Genesee Drive. My wife Val and I live adjacent to the north of this proposed project. I'm also speaking for my wife, neighbor Gary, and neighbor Hank. Good evening, Commissioners and Corey. At the meeting on April 13th, Mr. Lott spoke about cleaning up this property. May I share these with you?
If you would give one to our staff as well, for the record.
He also spoke about hauling off junk cars. It's funny, but I've lived adjacent to this property for 34 years, and I don't remember any junkers. And I trust that you all have read our side of this story. Here are a few key points. Ada County Zoning Ordinance, Section 8-2B-1C-1B. The proposed development exceeds the maximum allowed density in the R2 zone. This project is 760 feet shy of meeting that requirement. Section 8-8-5, the development would not cause undue damage, hazard, or nuisance to persons or property in the vicinity. I say that it will. More noise, traffic, people, and less privacy for us and our neighbors. On the subject of traffic, in the prior meeting, the representative from Centurion Engineers said that car trips would increase by 10 a day on Genesee Drive. That's 3,650 trips per year. Genesee Drive is a quarter mile long. Would you gentlemen like that in front of your homes? This information come from ACHD and was validated by Corey. Last but not least, I have a real hard time accepting some paid spokesperson from Centurion Engineers that doesn't even live in my neighborhood telling me how wonderful and how beneficial a house would be on this parcel of ground. In the event that you side with Mr. Lott, there are some conditions I request be met. First, a single-family, single-story dwelling. Second, for Mr. Lott to build a privacy wall on his north property line, 6 foot in the rear, 3 foot in the front. This happens before land sale or house construction. Do you folks have any questions for me?
Okay, yeah, I have a question. You gave us some pictures here. Is this a picture of the property that's in question?
Yes, they're all of those pictures are the property in question. That was the date that those pictures were taken on that yellow slip.
Okay. It would seem, and this is some of your objection as to the
Yes.
condition of the property. It would seem to me that if all that was gonna be cleaned up and a house be built there, it'd be benefit the neighborhood.
It's been like that for 15 years, and that house is going to look right in my backyard. And I've lived there for over 34 years. When I bought that property, the well lot was there, and I figured, this is a great deal. You know, nobody can build on it, it's too small, and then that's where we're at.
Mr. Chair.
Yeah, go ahead.
I guess I'm a little confused too. What point are you trying to make with the pictures?
The point I'm making with the pictures is that this is the way it looks now. If there's a house there, it isn't going to look any different, and I don't want the house looking in my backyard. My property and my backyard doesn't look like that.
I'm still a little confused. What do you mean if a house is there, it's not going to look any different? I assume all this would be cleaned up and there would be a house there.
I assume that it wouldn't be.
Well,
That's what's there now.
right. So if they built a house there, you don't think they would clean this stuff up?
Well, I guess it would remain to be seen.
Okay. And then your other request is that they would only be authorized to build a single-family, single-story home?
On that property, yes, it's very small. And I don't want a two-story house looking in my backyard. I don't want a single-story house looking into my backyard.
Sure.
I've been there for over 34 years. I'm proud of the neighborhood, I'm proud of my property, and I just don't think this will fit in. And I have a real problem having hired people telling me how wonderful it's going to be. And one of the biggest things is the increase in traffic. I don't know when the CHD said about the 10 trips, because the one we talked about up here was 2019 on that one. When was this one? Do you know, Corey?
You can have any information you want. You can direct to the chair and provide testimony.
Well, I don't know what that number, as far as the 10 trips a day, I don't know how current it was. That was just what come up in the last meeting.
Okay.
Right, Corey?
All right, any?
Are you saying that the 10 trips a day will come from the construction of the house, or once it's constructed?
Oh, it's according to last meeting, it was an increase in the property on Genesee, and she said that Genesee, that this new property, this new parcel, this new residence wouldn't affect Rutzel. Everything was coming out onto Genesee. And in the last meeting, ACHD, and it come from Centurion Engineers, said that there would be an increase of 10 trips per day on Genesee.
Mr. Chair.
That's 3,650 trips a year, extra in front of my house.
Okay, go ahead, give a question.
Could I just direct to staff, maybe you could address, I'm trying to figure out where the extra traffic's coming from and what's been said on the traffic issue previously.
Chairman, Commissioner Davidson, ACHD has, for certain types of uses, a number of trips they expect to be generated. So for any single-family dwelling, they expect 10 trips per day to come from that home.
So that's just standard, so it could be 2 a day, or it could be 5 a day, that they just say 10 a day on average.
Chairman, that's correct.
Okay.
Chairman and Commissioners, it's also important to note that a estimate of vehicle trips per day is not on the road directly in front of the use proposed. It's trips are calculated throughout the area that the use is proposed. It's not 10 cars every day in front of that home. It's leaving, going to the grocery store, dropping your kids at school, going to work, going to the grocery store after work, and coming home. All of those are going to the calculation of the trip. So it's a pattern of traffic across the area. It's not 10 trips directly in front of that home or on that street every day.
Okay, all right. All right, any other questions, Commissioner?
Not at this time.
Okay, thank you.
Thank you, guys.
All right, Anna Canning? Oh, you all right, you already spoke, all right. Anybody else wants to speak on this? Okay, you can, Anna, you can take 5 minutes to rebut if you'd like.
Chairman Beck, Commissioner Davidson, Anna Canning again, Centurion Engineers, just address a couple quick points. As addressed in the staff report, the proposed subdivision does comply with Ada County Code and the density requirements for the purpose statement of the zoning district. And I'm glad staff clarified the 10 trips per average. That was a better clarification than I could have made. Thank you. And with regard to the lot being very small, one is over half an acre, one is just under half an acre. The surrounding properties are just a little bit over half an acre. So that gives you an idea of how small they are. To me, that's a large lot, but I know it's all perspective and relative. And with that, I'll answer any questions you may have.
Okay, I don't have any questions. Do you have any questions?
Yeah, Mr. Chair. Is it already decided what style of house is planning to be built there?
No, sir.
Is it most likely going to be a single-story home? Or has there been any discussions on that?
Chairman Beck, Commissioner Davidson, I have not had any conversations with the owner of the property regarding a future home. He is here if you would like to ask him questions.
I'd love to ask him if he wants to come up.
Is there, you might can answer this, is there restrictive covenants in that subdivision that applies?
My recollection is yes. I can go check my records, or perhaps the owner knows he's coming.
Okay.
Hi, my name is Mike Lott. We own the property. We have no plans. There are no plans. We are just organizing the lot to be a buildable lot. The well house, pump house lot was not a buildable lot because it wasn't minimum 16,000 feet. When we moved in, the lot was for sale for a year, probably for 2 years, because it was for sale before we got there. And no one bought it, and we didn't go buy it. The water company called and asked us if we would be interested in it finally, and we negotiated a good price and purchased the property. And attempted to do a lot line adjustment to create this organization once in 2016. That didn't work. That was denied because of the 10% lot line adjustment rule. And now we're doing the final, full-on subdivision creation to create a half-acre lot that makes this a buildable lot. And we don't desire to build a house. We garden that area there. And so Ada County Planning and Zoning has agreed to suggested that they would give us 2 years to decide how to do this, either tear the shop down that's on that property currently or build a house there with the shop. Just so you know, that should answer your question.
Are you
And we
aware-
haven't decided that it's 1-story or 2-story, no.
Yeah, but are you, is there restrictive covenants associated with the property?
A restrictive governance,
Restrictive covenants.
no.
There, a lot of properties have restrictive covenants that govern the future use of the properties. Gives minimum sizes and things like that. It's quite common.
Yes, standard things like it can't be over 40 feet high or something like that.
But
I don't
it's-
remember. I do not know the answer to that.
A lot of subdivisions have different,
Tennessee has a protected covenants. I've got a copy of it.
all right, so there are protected covenants in the subdivision. Okay, that's.
There is no current homeowner association.
Well, you don't have to have a homeowner
All
association.
covenants are referred to a law office, if I remember right.
You don't have to have a homeowner association if you have protected covenants. Protected covenants are just deed restrictions is what they are.
Yeah, things like up front of the house, the side fence can't be more than 3 feet tall. Those kinds of things are in the
It depends
covenant.
on the see, it's up to the developer and people use, the developers use it as a way to protect future use of the properties. That's
Yes.
all. It's just a deed restriction is what it is. And if you have a deed and the gentleman says that there are deed restrictions, then that's what any future building would have to comply with the deed restrictions. Okay, I don't have any.
That's all I have.
Oh, all right,
Chair?
yeah.
Do you want to address some of the, potential privacy concerns of the neighbor? Nobody obviously wants a 2-story house looking into the yard, but he's asking about a privacy wall. Do you want to address some of those issues?
If it was a 2-story house, a privacy, 6-foot privacy wall would not solve any of that type of problem. What does already solve the problem are all the trees that exist there that are pretty dense. I can't see into his property. I mean, unless you walk over to the fence and look around the trees, through the trees, you can't see in his backyard at all.
You can if you look through the knots in the
Oh,
fence.
sir, please don't interrupt.
Yeah, there's no privacy issues, whether it were a single story or 2-story house. The trees look like they were planted in the 70s and they're very tall. They're big pine trees, so they're evergreen, and they are very private for his backyard.
Okay, any other questions? Okay, thank you, sir.
Yeah, thank you.
Okay,
Planted in the 90s, Mike.
all right, before we close the public hearing, would you enter this evidence into the record?
Chairman Commissioner Davidson, those photos will be entered into the record as Exhibit 36.
Okay, any other comments or issues that people want to bring up? No, you've already spoken, sir. Any other? Okay, with that, I will close the public hearing on application number 2023-00186S-VAC, Centurion Engineering. Okay, it's up to the board now. Would you like to kick it off, Commissioner, or you want me to?
I can kick it off if you'd
Okay,
like.
go ahead.
Appreciate everybody coming out and testifying. Listening to the evidence, I understand the concerns about privacy and traffic. They're always common concerns when any new development is occurring. I think one of the standards we have to look at when we address these issues is whether it's a reasonable or unreasonable infringement on somebody else's property or peace and quiet. And I think generally, we look at the fact that, you are going to be disturbed when anything is being built next to your house. Is that an unreasonable amount of disruption? I don't think we can interpret it that way because it's one of the prices you got to pay to live in a city. Things are going to get built next to you. I think again, I do understand the privacy concerns. I understand the traffic. I haven't seen any real evidence that I would say it would make any of those an unreasonable infringement. It's an infringement, to be sure. but I don't think it's necessarily more unreasonable than any regular construction that we see. It does sound like from the evidence we've heard that there are trees covering the view to the neighbor's property. I don't know if forcing them to install a privacy wall is called for. I think, additional trees or bushes could be planted if that becomes an issue. We're just not feeling that it would be reasonable to require the wall based on the evidence I've heard. So I am leaning towards approving this. Certainly hope that the yard does get cleaned up. I don't know if we're looking at potential code enforcement issues. I don't know if the pictures that the neighbor took are visible from the street, but that may fall under code enforcement for having, excessive junk or materials in the yard, but I'll leave that up to others. So I am leaning towards approving this application.
Okay. The application the hearing is closed on this application. I'll accept a motion.
Well, Mr. Chair, I am going to move to accept application number 202-300-186-S-VAC, Centurion Engineering.
It's approved, the application.
Sorry, approve application 202-300-186-S-VAC based on the testimony we've heard tonight and the staff report.
Okay, I'll second that motion. Is there any further discussion on the application? Hearing none, those in favor say aye. Aye. Motion carries. Thank you. Okay, we will, next. Could you grab Commissioner Daley? I'll open the public hearing on application 202-300-319, ZCDA MSP Hawkins Companies Commercial Developers. Okay, we'll hear first from our staff. Give us a staff report.
Mr. Chairman and Commissioners, project number 2023-00319 ZC-DA-MSP is a zone change development agreement and master site plan to rezone a property from the Southwest Community Residential District to the Community Commercial District, along with a proposal for future phase commercial development. The property is located at 6080 South 5 Mile Road. It contains 2.5 acres. The property is in the southwest Boise area near the intersection of Lake Hazel and 5 Mile Roads. And this picture here kind of gives a brief overview of kind of the general area of where that property is. You can kind of see there's a number of residential subdivisions kind of near that intersection of 5 Mile and Lake Hazel. The property owner, the applicant, has applied to rezone the property to the Community Commercial C2 District, which is similar to the zone that's to the south and across the street. The purpose statement of the Community Commercial District is to establish areas for community shopping, clustered commercial activities along arterial streets that provide for the sale of a full range of merchandise and services required of persons living within several neighborhood service areas, as well as a rural trade area. The property is located in Boise's area of impact, and the applicable comprehensive plan is the Boise Comprehensive Plan as adopted by Ada County. The comprehensive plan shows the intersection of West Lake Hazel Road and South 5 Mile Road as a community activity center. Community activity centers are intended to meet the needs of a group of neighborhoods or the entire community. They are characterized as destinations that include grocery store anchors, moderate to high density housing, office and service uses, and mixed use development. There is commercial development on all four corners of the Lake Hazel and 5 Mile Road intersection. At the southwest, or at the northeast corner of the intersection, we have the McDonald's restaurant, and there's a future retail pad directly to the east of the McDonald's. And then on the southeast corner of the intersection, we have the Albertsons grocery store, a branch of the Ada Community Library, a pizza restaurant. There's a gas station and a St. Alphonsus urgent care facility. On the southwest corner of the intersection, we have a gas station, and then we have the Hazelwood Marketplace. The Hazelwood Marketplace has a Zamzo's. I think there's like a Verizon's wireless store, and there's an ice cream shop and a coffee shop in that shopping center. And then on the northwest corner of the intersection, we have the Walgreens drugstore, and then we have the Iowa Central Credit Union, which I think just recently got built. And then we have the Les Schwab Tire shop, which is currently under construction. The master site plan consists of construction of a 7,400 square foot retail store with future retail plans for another retail pad on the site. The retail store will be located at the southern part of the parcel, and the future retail store will be located in the northern part of the site. The future retail store, which would be on the northern part of the parcel, will require a separate master site plan application once the applicant is ready to design and build the second building. The applicant has provided 2 conceptual plans to serve as examples of how the northern portion of the site could be developed. So the first option we have up on the screen is option 1, and we have the proposed 7,400 square foot site along the southern boundary, and then we have kind of a northern retail site to the north. And then to the northeast corner of the site would be kind of where the septic system and drain field is. And the applicant is, for that site, would kind of have that as a kind of a nice amenity for the commercial development. And then for conceptual site plan for option 2 has the septic system and drain field kind of in the center of the site. And that would be an amenity as well. A unique aspect to this project is that the property is unable to connect to Boise's sewer system. Years ago, the city had extended municipal sewer outside of city limits, and this provided a centralized sewer system to several subdivisions and properties in Boise's impact area outside of the area of outside of city limits. And this includes nearby subdivisions and properties adjacent to the subject property. A few years ago, the city amended their sewer policy, and that it will no longer extend sewer outside of city limits unless the property had access to an existing pipeline or a development application had been submitted prior to the effective date of the most recent revision of the sewer extension policy, which is July 22nd, 2014. The applicant has stated in their detail letter that they would like to connect to a centralized sewer system. However, they've been unsuccessful in obtaining a sewer connection from the city. Therefore, they're proposing for the development to be served by an individual septic system. Section 8-4A-22 of the Ada County Code states that new development within an urban service planning area shall be served by urban public facilities. The subject property is within Boise's urban service planning area. Thus, this requires for the proposed development to connect to a centralized water and sewer system. The applicant has provided a will serve letter for a centralized water system from Veolia Water. However, the development isn't in compliance with section 8-4A-22 as it will not be able to connect to a centralized sewer system. We have received numerous comments from the public in favor of this project. Nearby property owners have provided letters in support of the project indicating a desire for more commercial businesses to locate in the area. The Southwest Ada County Alliance is lending its support to the project. They support the use of the property as commercial rather than residential. They would like for the primary use to be a walking coffee shop or restaurant where people can meet, sit, and visit. If a drive-through is approved, they ask for the utmost consideration for the nearby residential homes. They also ask for the streetscape and interior parking lot to be designed in a pedestrian-oriented manner. Several agencies have provided comments on this application. The Boise Public Works Department stated that sewer is currently not available to the property. The Central District Health Department replied that they will require more data concerning the depth of waste flow characteristics. The applicant's engineer has stated that based on a review of soils information available for the area and the proposed site plan that a standard septic system should adequately provide sewer disposal, assuming the site is limited to 2 of the following users: a drive-through coffee shop, auto parts store, or oil change center. Brent Moore, Senior Community and Regional Planner, responded that the proposed commercial zoning designation and retail building are compatible with the adopted future land use map. The Boise Planning and Development Services Department did state that the site is not eligible for a sewer extension, and they do not support the use of a septic system for the project. They mentioned that Blueprint Boise, their comprehensive plan, provides an overall vision of how Boise's activity centers can develop, but does not speak to the sequence or order of development. They also state that ground level development should facilitate active uses such as retail shops and restaurants to provide pedestrian interest. The proposed development provides the opportunity for increased commercial activity, but does not adequately promote the compact, pedestrian, and transit-oriented development intended for mixed-use activity centers. They also state that the Boise Pathways Master Plan identifies a proposed pathway on the eastern edge of the site along the Hahn Lateral. This critical link will support a 1.65-mile pathway that connects residents from the intersection of Cloverdale and Amity Road to the Lake Hazel and 5 Mile Community Activity Center. If the rezone is granted, they do request that the applicant be required to install a 12-foot wide concrete path for public use with a recorded public access easement. Due to the lack of municipal services available at this time, they recommend a denial of the project. When staff presented this application to the Planning and Zoning Commission at their April 13th, 2023 public hearing, staff had recommended denial to the Planning and Zoning Commission. Staff's recommendation for denial to the Planning and Zoning Commission was due to the applicant not being able to connect to Boise City Sewer. If the development were able to connect to the sewer, staff would have recommended approval of the project to the Planning and Zoning Commission. The Planning and Zoning Commission voted to recommend approval of this project to the board. At their public hearing, they found that hooking up to a centralized sewer system is preferable over an individual septic system. However, they found that the needs of the residents outweigh leaving the property as a single-family residence until the property is annexed and sewer is available. They also considered the development of the site to be infill development as the site is in close proximity to other commercial developments, rather than its current use as a single-family residence on a large lot. It should be noted that as a condition of approval, the applicant will need to receive approval from the Central District Health Department for the proposed septic system before any construction permits are issued. And I'll stand for any questions. And then this presentation will be exhibit number 65.
Okay, are there any questions?
Mr. Chair,
Go ahead.
so the city of Boise wants these community commercial hubs. I mean, this is what they want. This seems to fit that designation. Can you explain why they feel it's not to their liking?
Mr. Chairman, Commissioner Davidson, I believe kind of with the sewer extension policy, they want to control the development that's occurring within the area of impact. And so I think it's more their, political philosophy that, if there's development in the area of impact, that it should occur once the property is in city limits. And so I think part of that's more of a control aspect. And so I think that's kind of the main reason, why they had a recommended denial of the project to you.
How many commercial developments do we get that end up being on septic instead of sewer?
I would say in the Southwest, most of the commercial developments that have been approved in the Southwest Boise area have been on, the city sewer system. So like the Walgreens and the Charlesworth development, which would have the Iowa Central Credit Union, the Les Schwab Tire Shop, the Hazelwood Marketplace on the other side of Lake Hazel Road. Those are all commercial developments that are on the city sewer, systems. I can't recall, really recently, too many, commercial developments that have been approved with a septic system, and maybe Richard or Leon might have some information to share there. I believe there are probably some, commercial developments out in the county that do have septic systems, that are fairly older commercial developments, but I don't know exactly which ones are on sewer and which ones are on septic systems.
Yeah, Mr. Chairman, Commissioners, just to add to the information Brent shared, as he stated already, the code really directs these urban uses to where the urban public services are. However, there was the most recent example of a commercial development that I can think is there was a gas station out south of Meridian that was approved by our Planning and Zoning Commission on a septic system with the understanding that when the sewer became available, they would connect that facility to the sewer system. But generally, it's somewhat rare. We have some older commercial areas and different uses out there that are on septic systems, but it's not typical.
Okay?
I have a question.
Yeah, go ahead.
So in the Boise City, so you, correct me if I'm wrong, you said all the other development on the west side, the Walgreens, the Les Schwab's, and the credit union are all in Boise City sewer?
That is correct, Commissioner Daly.
McDonald's is not?
Mr. Chairman, Commissioner Daly, McDonald's is also on the city sewer as well.
So why are they saying no to this one?
Well, Mr. Chairman, Commissioner Daly, it's based on their sewer policy. So with the Charlesworth development to the west, that was part of the Hazelwood subdivision. And so Tucker Johnson, came in probably about 20 years ago, had brought the infrastructure for the sewer to that site when he developed Hazelwood subdivision. And so because there was that kind of, I believe it's the previous entitlement with Hazelwood subdivision, because Tucker had brought the sewer there, then therefore they had a right to develop that ground into the Charlesworth subdivision. So when, Tucker Johnson sold it to Hubble Homes, and Hubble Homes developed into the current Charlesworth subdivision, which has residential and commercial components, that occurred kind of under a previous entitlement that was approved before the city sewer policy went into effect. With the McDonald's project, there was already a pipeline extending from Lake Hazel to the McDonald's property site. And so because there was already a connection already there on the McDonald's property was then able to hook up to the sewer as well.
So it's available, they're just saying they can't use it.
That's correct. So basically with the...
It seems unreasonable to me that the city, it's available, but they just saying, no, you can't use it.
So, Mr. Chairman, Commissioner Daly, so I think the reason why the city is saying no, because there's currently not a sewer pipeline going from the trunk line to the subject property. So if there had been like the McDonald's property, there had been a service line going from the sewer main line trunk to the subject property, then they would have probably had the ability to hook up and have sewer. But because there's not a service line from the subject property going to the main sewer trunk line, the city says that they're not able to hook up.
Well,
Strange.
that line could be easily built, could it not?
Mr. Chairman, I believe it could, yes.
Yeah, what it is, it's just a policy. There's lots of sewer capacity out there. It's just that the city of Boise has adopted a policy I thought their policy was they allowed one access per property. Is that not right, their policy?
Chairman, Commissioner, to Brent's earlier recall of the moratorium, and I'm sure the applicant can share this with you as well, because early on in the process, we encouraged them to go see if they could connect to Boise, and based on that policy, it either had to be a previously entitled property like Hazelwood Village or Charter Point, or it had to have an existing service line into the property, I believe. Those are the only two ways you get sewer out in this area, even if it exists literally out in your front street. You just can't connect because of the moratorium policy, so.
It's a policy, it's not an infrastructure issue at all. It's just a policy. Okay, all right, thank you. Any other questions of our staff before we hear from the applicant? Okay.
Good evening, Chairman Beck, Commissioners. My name's Ethan Mansfield. I'm with Hawkins Companies. Address is 855 West Broad Street, Boise, Idaho, 83702. Before I start, I'd like to also echo my praise for the Ada County staff. Brent and Leon have done a really excellent job working with us on this application, and I think they're great planners. So I'd like to just discuss a little bit of our situation and our request for a commercial development at 6080 South 5 Mile Road. Go ahead, Brent. Do I have a clicker, or are you gonna?
I guess
run
I
it
have
for
to
me?
do it, yeah.
Right on, sounds great. The property is about 2.5 acres. It's located at 6080 South 5 Mile, just north of Lake Hazel Road on 5 Mile. So Brent went through the concept plans. Here they are again. Building A is a 7,400 square foot retail building proposed. In this concept plan, Building B would be a quick lube oil service. And the next concept plan shows a coffee or kind of drink user on that northern portion. So why are we proposing commercial development here? Well, we've seen tons of interest from commercial users for this site. It's a great corner. It's busy. There's tons of residential development surrounding it. And there's a lot of demand for services from both the users and from those residences. We've also seen that Boise City themselves and neighborhood comments on previous applications, specifically on the Alante Homes application, which was before you several months ago, echoed the sentiment that more commercial services were desired. Boise City says, the activity center at Lake Hazel and 5 Mile has the potential to serve as an anchor of employment and commercial opportunity that is accessible by walking or short local trips for residents in this area. An opportunity that residents of the Southwest Planning Area have repeatedly asked the city of Boise to support. Southwest Ada County Alliance says something similar. Our Southwest community has an abundance of rooftops and a lack of corresponding services and commercial businesses. For years now, we have been told to be patient, that commercial development will follow once there is enough densities to support it. With the traffic issues that Southwest Boise is already facing, anything we can do to make trips shorter will help relieve congestion. And there was a neighborhood petition that was submitted as part of the record for this particular application. The dearth of commercial enterprises in this region of Southwest Ada County already affects neighbors from miles around who must drive long distances for shopping, personal care, entertainment, increasing traffic rates throughout the county. So we can see there's tons of demand for services. And we've also received comments on this application that reflect that demand. One neighbor, Carlos Vidales, and I think he may be on here. I saw him earlier, but he may have jumped off. He wrote that the proposal most positively contributes to enhancing the community center at the corner of Lake Hazel and 5 Mile Roads. Not only is this parcel a natural for business, but the proposed construction would positively impact thousands of homes within a short driving distance. Southwest Ada County Alliance also supported the use as commercial space rather than residential, as Brent mentioned. And then finally, Brent Moore, the esteemed long-range planner, says that the future land use map further designates the property as being within a community activity center, which is intended to include a variety of retail, office, and service uses that will meet the needs of surrounding neighborhoods and within which retail is listed as a primary use. As such, the proposed commercial zoning designation and retail building are compatible with the adopted future land use map. Thanks, Brent. And so here's just a snapshot of some of the more recently approved residential developments that this commercial development proposes to serve. So I think planning and zoning's recommendation and Brent's recommendation say it all. Staff's recommendation for denial is due to the applicant not being able to connect to Boise City Sewer. If the development was able to connect to sewer, staff would have recommended approval of the project. And Planning and Zoning Commission recommended approval for this reason. I should state that we were very much interested in connecting to sewer. It would allow us to do a restaurant, for example. It would allow us to put real, more intense commercial services to better serve the surrounding neighborhoods. But of course, when we went to the city of Boise, they said, no way, Jose. You're not getting sewer to this property. And so that forced us to look for other alternatives, and finally, we settled on septic. Next slide, please, Brent. And this is the reason. In 2017, the city of Boise amended its sewer extension policy, also known as the sewer moratorium, to require that a site either annex into the city or have an approved plat or development application approved for sewer extension on it prior to July 22nd, 2014. And if a sewer line is not adjacent to the site and the site cannot be annexed and was not platted with sewer approval prior to 2014, then the city will not allow extension of its sewer system to the site. So the resulting land use pattern of this policy looks like this. In yellow, you can see where sewer has been extended, and the places that are not shaded represent places where sewer is not allowed to extend. And you can see our property in red there. The reason that all of these other commercial developments on this corner are connected to sewer is because the sewer moratorium language allows for those to connect and does not allow for ours to connect. So let's talk a little bit about what's currently allowed on the property. Right now, the property is being used as intensely as possible. It's zoned RSW, which allows for one single-family home for every 2.5 acre parcel. That's what's on it now, and that's what will remain if the rezone's not approved. We, as I said, prefer to connect to sewer. We've asked the city of Boise repeatedly if we could pay to extend the sewer north from Lake Hazel and connect it to our property. So currently, the sewer line is within Lake Hazel, and we've offered to pay for that extension, and the city has said, nope. So we also explored a sewer easement across the McDonald's property, and the moratorium does not allow easements across other private property. We also explored purchasing land from McDonald's to give us frontage on Lake Hazel so that we could use one of the 3 sewer stubs that are sitting in front of the McDonald's property. And McDonald's would not sell us frontage. They would sell us parts of the land, but they would not sell us frontage. And without street frontage, Mike Shepard at the city of Boise made it very clear, there's no way that you are connecting to sewer. So as such, we're proposing to dry line our buildings, which is essentially to prepare them for the extension of sewer when it occurs, so that when sewer is brought down 5 Mile, whenever the city allows that, we are prepared to, or the tenants will be prepared to connect their buildings into the sewer line. So we are totally in agreement of any condition that would require us to connect when the sewer is extended. And so, long and short, annexation is required to get sewer. Well, we're not opposed to annexing either, but the city boundary is 2 miles away. And there are thousands of parcels that would need to annex before we were able to. So we are, again, open to annexing. However, it's currently impossible. Next slide, please. And it could be 5 years or more likely closer to 50 years before this parcel is eligible for annexation. And the city currently does not have any plans to annex the property. So there's not really an annexation roadmap that suggests how we would get to be annexed. So that's also a challenge we're facing. Meanwhile, services are demanded by the surrounding residents now. Of course, they will be in 50 years as well. But that demand is very strong right now, which is why we're coming forward with this proposal. So really, as I see it, there are 2 kind of land use trajectories here. An approval of this application will allow our development on septic, of course, pending Central District Health approval. We've been in discussion with them. We're well aware that we're not just going to go dig a hole and put a septic tank in the ground and call it good. We obviously have to get approvals from Central District Health. And this allows a use that is consistent with the future land use map within the comprehensive plan. A denial basically prevents the development of this parcel until it is annexed by the city. Because right now, there's no sewer. we're at our most intense use. It's going to be a single-family home until whenever it gets annexed. 5 years, 50 years, 200 years? Difficult to say. And that use is inconsistent with the comp plan's future land use map. Next slide, please. So we have spoken with our engineer who, did some preliminary work to understand if septic was viable, because obviously we wouldn't be pursuing this if we didn't think septic was viable. He confirmed that it was. We've also met with Central District Health, who also preliminarily says, yeah, I don't see any reason why it couldn't happen. Of course, we need to submit construction documents for that. And then one condition of approval that I'd just like to talk about, I'll be relatively brief here, is the condition for a 16-foot easement along the eastern boundary of our property adjacent to the canal easement. The city of Boise recommended this 16-foot pathway easement, and it made it in the conditions of approval. The applicant and/or owner shall record a public access easement for a 12-foot wide concrete pathway along the easterly boundary of the subject property. That looks like a 16-foot easement to accommodate 2 feet on either side for drainage. And you can see where the easement's located on this site plan. Next slide, please, Brent. Now, we are overall very supportive of increased bike and pedestrian connectivity. I ride my bike to work almost every day, live up on the bench, bike downtown. I appreciate pathways, shared use pathways. I really do. The frustrating thing about this is this pathway, we don't feel will be able to connect to anything. And here's why. Brent, next slide, please. This is, really quickly, actually, before you leave, this is the proposed, one slide back, please, Brent. This is the proposed pathways plan that the city of Boise has put into place. And as you can see, it generally follows laterals. Now, the issue with that is that, next slide, please, Brent, is that the irrigation company, specifically this irrigation company, the Boise Board of Control, will not allow pathways within their easement. Fair enough. It is what it is. It would be nice if they would, because you could have these pathway systems. However, they have adamantly recommended that they will not. Hence why we are asked to dedicate the additional 16-foot. And again, we're not immediately opposed to doing that. However, we're opposed to doing it simply because of the lack of surrounding connectivity. This north side is not such an issue. The blue is kind of where the future pathway will go. We anticipate that the property to the north will also be asked the same thing. And, it very well may happen. McDonald's has also agreed to a 16-foot pathway to our south. That portion, no problem. Next slide, please, Brent. The issues arise when you cross the street to the south. This is the pathways plan. And again, the Boise Board of Control, the irrigation district, says no pathway in our easement. Well, if you look closely, the route of the pathway, if it cannot be placed in the canal company's easement, basically traverses all of these parcels, single-family home parcels' backyards. These are diverse owners. This is not one owner controlling all of the parcels along the pathway easement. There are thousands, right here, even hundreds, even in this short quarter-mile distance, hundreds of different owners that we need to be coordinated with to say, hey, can we take 16 feet of your backyard and turn it into a public pathway? And we think that lift is unrealistic for anybody to undertake. Now, the alternative is to go to the canal company and say, canal company, can we please put a pathway in your easement? Well, in that case, if the canal company allows it, then they would allow a pathway in their easement along the back of our property as well. And we would absolutely support, if there was pedestrian connectivity there, that's fantastic. So next slide, please. Here's just a close-up showing kind of what I'm talking about. You can see that common lot through the subdivision. That common lot encapsulates in its entirety only the canal easement. So where the blue line is where the pathway is envisioned. And then next slide, please, Brent. But really, you can't put a pathway there. You have to actually put it in somebody's backyard. And in many cases, specifically in the more recently platted subdivision, there simply is not enough room to construct a pathway outside of that easement. So there really just won't be a pathway until the canal company allows it. And that's why we're saying, next slide, please, Brent. We would request that staff remove, or that you would allow staff to remove condition number 8 from the report. Thank you very much. I'll stand for any questions. I know that's a lot.
Okay, any questions?
I just have, this is a hypothetical question for you because you live in the city of Boise. Do you now understand why nobody out in the area wants to be a part of the city of Boise?
Commissioner Daly.
I live out there, that's why I said that.
Commissioner Daly, I completely understand.
It's totally unreasonable.
Yeah. All right. Any other question?
So one thing I find interesting is, you mentioned one of the other projects that was, I think it was Alante, is that the one we denied? That one was interesting because those developers are saying, well, we can't find any commercial who wants to come to this intersection, so we want to build residences, and you're saying you're getting all kinds of demand. So I'm not sure what the disconnect is. You would think that is this a new phenomena that commercial wants to build out there, or I guess I'm asking you to speculate about the other project that.
Commissioner Davidson, that is a fantastic question, and I myself had the same question for our development team. And the answer, as it turns out, is it's purely based on the location of the specific parcel. So commercial development wants to locate on the north side of Lake Hazel and is less excited about the south side. In addition, the Alante Homes project was actually not on the hard corner. It was tucked back behind the existing commercial. And so there's just simply a lot less demand for commercial uses in that location. Not only is it south of Lake Hazel, where there's much fewer vehicle trips right on 5 Mile, because 5 Mile kind of hits Lake Hazel and then people go on Lake Hazel. They don't continue, very few continue south, relatively speaking. And so the demand is really focused on that northern portion as well as being visible from the street. That's very important to commercial users. And so this is, again, speculation. We're not like talking to every single commercial user, but this is kind of, something that was news to me when I spoke with our development team.
Now, you've got the neighborhood, they're in support of this, Southwest Neighborhood Alliance. Always amused at some of the neighbors' comments where we want a coffee store, we want a museum, or whatever. I hope people understand we have no ability to mandate what you put on a commercial development, nor do I think we should have that power. It's up to you guys to if you're approved, to put what you want there. But I would hope that you do maybe have some conversations with the neighborhood and get their ideas, because if you build something that they want, hopefully it'll increase your profits and just the overall desirability of the neighborhood.
Commissioner Davidson, absolutely. And in our neighborhood meeting, we took some pretty good notes and specific feedback about not just the types of uses they want, but also the types of design features they'd like. And so we took some of that into account. One thing that I didn't mention is with this 16-foot pathway or easement, we had planned to install an additional tree buffer in addition to our fence buffering the canal easement. We won't really have much space to fit those trees in there once that easement is in there, because there's no trees allowed in that pathway easement. Unless, of course, the easement language is specifically crafted to allow plantings in there. But typically that's not seen. So we committed to doing that before the easement was in place. We also had a fencing along the north side. We have also kind of oriented the way that drive-through is oriented to minimize any sort of headlight into the neighboring property. So we thought a lot about that in design. We also committed to the Southwest Ada County Alliance to install a raised crosswalk on that northern crosswalk, which is something that Marissa Keith specifically asked for, and we're more than happy to do that in exchange for their support. So.
Now, with regard to the pathway, in your presentation, you really make it look like, what Boise's contemplating is not feasible at all. Have you actually had conversations with them, and where's their mind at why they think that this can actually be done?
Yeah, that's another great question, Commissioner Davidson. You know, they try to plan for the future. They are not as, I've read through the Pathways Plan extensively, and I actually am great friends with the guy who created it, and I really respect the Pathways Plan, and I respect the man who created it. However, you know, it's clear in reading it that there's not a lot of implementation strategy, perhaps. It's more like, if you can get it, you know, try and get these sections. Here's a guide. Here's a guide that allows you to come in and say, we want our pathway here. And so when you have an opportunity, grab it. And I think, and that's not, I don't want to minimize the work that Boise City is doing with the canal companies, but I would really, really encourage them to continue that work if they're truly intent on making the pathway system work, because it clearly won't work by taking individual property owners 16 foot of their backyards for hundreds of properties. So, you know, I've spoken with the city of Boise multiple times about it, not specifically regarding this application, but outside of this application.
If we didn't grant the easement, are you still able to leave, you know, that section undeveloped? So if in the future this actually, you know, the pathway did go through, that you wouldn't have a development on there and a pathway could be built?
I think the way the pathway would go through, Commissioner Davidson, great question again, is that it would be built within the easement of the Boise Board of Control. Because if the only way the pathway would be successful is if it were built in the easement, we will certainly leave a small buffer for the trees. I can, you know, look to our development partner, Bronson, for a little bit more clarity on that. And, you know, we can certainly look at that if that was something that was of interest.
And does your company have experience doing commercial developments with septic tanks? I mean, is this, what's your history with that? Is this going to work?
Yeah, Commissioner Davidson, yet again, another great question. We've been doing commercial development since 1970, I think it's 76 or it's 73, don't quote me on that, but since the mid-70s. It's a lot of years. We certainly have developed commercial projects on septic and are actually working on one right now, I believe, in Reading. Is that correct, Bronson? So yes, we do have tons of experience with commercial development, and B, we have developed commercial properties on septic systems before in the past. We also trust our engineer immensely. KM Engineering is a wonderful partner, and Joe Patchner there has tons of experience doing septic work.
Maybe if we approve this, you could go back to Boise and say, well, we're going to build this anyways. They gave us approval. Please let us have the access to sewer.
We might just, we honestly, that's not outside the realm of possibility, sir.
All right, thank you.
Another question.
Yeah, go ahead.
Can you leverage the city of Boise wants to pass away, but they won't connect to a sewer, so, I mean, that doesn't make sense. So can you leverage the pathway for the sewer connection?
We can certainly try, Commissioner Daly. The challenge is, you know, we've offered to connect to sewer, and they've said, nope, and you have to do the pathway. They actually wanted us to build the pathway, and we spoke with the county, and the county says, you don't have to build the pathway, but you have to, you know, provide the 16-foot easement. So my hunch is that since we've asked them to provide sewer, and then they've said no, and they've also asked us to do the pathway, that there's not much of a, you know, they're basically like, you have to do this, this, and this. No questions, please. That's our experience with this particular project.
And as an aside, when I looked at that map, that other development, I wasn't here when the commission made their decision on that other one, but it seemed to me that it was another isolated tract that didn't have sewer connection, based on that map, anyway. But anyway, that's an aside.
Commissioner Daly, to the north of our property?
No, the one south that they were talking about, the south of Lake Hazel, that corner there.
Oh, yes. They, for some reason, were granted a sewer connection.
They did have sewer connectivity, but that wasn't the reason for our denial.
Okay. Just, it looked like on the map that it was.
Yeah, Mr. Chairman, Commissioner Daly, you're correct. The map did show that it wasn't in the yellow shaded area, but they did have a connection. And then it should be noted on the regional, on this pathway, even though the regional, I guess, aspect of the plan may be questionable, there could still be benefit for a pedestrian connection between the, I guess, behind the 3 undeveloped parcels, behind the McDonald's, behind this piece and the north piece, connecting 5 Mile to Lake Hazel. There still could be benefit there that you may want to consider as well.
That was going to be one of my questions as well. Back to follow up with Commissioner Davidson's question. Could you do it in a way, because it's 16 foot, so that you could have trees and then still put a pathway in there at some point in time? They're not mutually exclusive, are they?
Commissioner Daly, we're certainly not opposed to planting some trees in there if the language is crafted such that we can put trees in there. And then, of course, when the jurisdiction came in and installed the pathway, they would probably have to tear out those trees. There would be a 12-foot pathway, 2 feet on either side. I don't think trees could survive in the 2 feet. But that's just, I'm not a landscape architect, so.
Nor am I. That's why I was asking the question, because back to what the staff was saying, that it could be a nice pathway around that corner, I mean, that triangle,
Commissioner Daly, you're absolutely correct.
even just as an isolated pathway
Sure,
in that community.
sure.
Chairman, Commissioners, I will add to that, Boise has expressed some willingness to flex on design standards for this. They have kind of some minimum pathway widths and different things like that. So again, there is an opportunity to kind of get into whatever that easement agreement looks like between, and it's actually just a dedicated public access easement that Boise would, whoa. Sorry, I didn't want to hear my voice that loud this late at night. That eventually Boise would step in and say, okay, this is ours, we can get this pathway done now. I think there's going to be a lot of that design discussion down the road. And so we have just hey, give us 16 feet right now. And to Brent's point earlier and Ethan's point, they did say also build this pathway, which for us personally was like, that doesn't make any sense. We're going to build a path that doesn't connect to anything on either side. So we kind of took Boise's recommendation and just said, give us an easement, and then we'll figure out that design later. So I think that there is room to figure out landscaping and things like that. Pathway widths might be 10 versus 12 feet. I mean, there's going to be some of that discussion. I think we'd want to keep, again, if you're going to keep that condition language, keep it general enough that we can explore those design options down the road.
That's where I was going. Keep it in a way that it's an option available, not mandated, but an option available, because that pathway would be useful across that if it were ever connected.
Okay, any other questions?
Not at the moment.
Okay, thank you, sir.
Commissioners.
All right, Marcy Myers. Hello, Marcy.
Hi,
You have 3 minutes.
I'm timing me.
No,
I'm Marcy
you'll see-
Myers.
You'll see the time in front of you there.
Well,
There.
then start it, go. I live at 6080 South 5 Mile. That's my property that's in question. That we bought the property in 2016 because my husband wanted to build a big shop, put all these cars in it. Life is great, things were great. He passed away from COVID. I'm left with a big shop, a field full of weeds, and I physically and financially cannot maintain this property. Living out there with no services, I feel for the neighbors because I spend 30 to 40 minutes driving to places that I need to go to get any type of service. The commercial development is imperative that it happen out there. And I'm willing to give up my property to do it because the place is an eyesore, let's face it. It's just I just can't keep it up anymore, and I've got to do something. I can't sell it residential because I would get pennies on a dollar. And, oh, and speaking of the pathway, they have to put sidewalks down 5 Mile and Lake Hazel, so I don't understand the pathway. It's not going to connect. You can get further on the sidewalk on 5 Mile and Lake Hazel than you can the pathway. Come on, common sense? Just saying.
All right.
Any questions?
I'll find out. Are there any questions for,
None from me.
Thank you.
did you have any, okay, fine. No questions. We have Carlos Vidalis. Is he online? Is Carlos online now? Hello, Carlos?
Can you hear me?
Yeah.
Yes, can you hear me?
We can hear you just fine.
Yes, thank you, Chairman Beck, Commissioner Davidson, Commissioner Daly. Thank you very much for the opportunity to speak today. I am out of town. I was not able to be there in person. As I said, my name is Carlos Vidalis. I live at 163 West Oleana Drive, and it's about 1,000 steps from my front door to the property in question. And I'd like to say that Ethan did not take my name in vain. I really do support this project. To my knowledge, this is the first time I've seen a request to rezone from residential to commercial. It's a rarity. And this area of Ada County is about 2 miles from the center, from the epicenter. Is about 6,800 acres of land. In the area, we have only under 40 businesses, including the ICCU new building and the tire store that is being built. So that works out to about 700 residents per business. Meanwhile, in Boise, if we have the same number of people in that area, they have about one business for every 30 residences. So, what happens is that we have to drive long distances, and once you have so many people together, the miles accumulate. We like to shorten the distance to go shopping. Any kind of retail business will help. In this particular case, Hawkins Companies is proposing 2 more businesses. That's a 5% increase in the number of businesses in the area. So the special circumstances that we talked about is that the city of Boise is denying the sewer hookup to this location. But the Hawkins Company is willing to do a septic tank. There's thousands of homes in the area with septic tanks. It's an all tried and true technology. I don't see why it couldn't work. Plus, the Hawkins Company will also put the dry lines in there, getting ready to connect whenever the sewer comes, if anything. I'd just like to say finally that, this policy by the city of Boise is really messing up the entire South Ada County area, perhaps some more. I do not know how to resolve it. It's extremely unfair. I don't see any good rationale for it other than control. It is what it is. But you see, the septic tank is still a problem. And I was immensely grateful to the Hawkins Company that they are willing to do commercial development and willing to put in the septic tank to get around the problem. So with that said, if you have any questions for me, I'll be happy to answer them, but I'd like to reiterate that I do support this project. Thank you.
Thank you, Carlos. Are there any questions for Carlos? From the commission? No. Okay, nope, there's no questions. Thank you very much, Carlos.
Thank you.
Is there anyone else that wishes to testify? There's nobody else in the audience, I guess. Okay. You can, the applicant can rebut if you want to, but I don't know what you'd be rebutting.
I think we're all right. Thank you very
Yeah,
much.
you can take a few minutes to rebut, but okay. All right, well, given that,
Mr. Chairman, before you close the public hearing, we will want to enter the applicant's presentation as exhibit number 66 into the record.
okay, we got that.
Chair,
Yes.
just a question to staff. There were some additional discussions about ACHD and the owner of the property to the south, McDonald's, and I think we've kind of worked that out, haven't we? Or found a solution to that.
Chairman, Commissioners, I think you might be speaking to cross-access and access to 5 Mile, and I believe the conditions we have in place are the ones the county felt comfortable with, and certainly it's at your discretion if you wanted to modify any of those, but, and Brent could speak to that issue as well, and I guess you might want to let the applicant speak to it if you're going to make any change, but I do believe we've come to a conclusion on that.
Mr. Chairman?
Yes.
I think it was my understanding that that was an Ada County Highway District issue and not our issue to
Yeah,
address.
I think that's correct. And so if there's any other, so you've got the applicant's his presentation as part of the file now?
That is correct, Mr. Chairman.
Okay. Do we need anything else before we close the hearing? Okay. Hearing nothing else, I will close the public hearing on application 2023-00319, ZCDA MSP, Hawkins Companies Commercial Development. And it's now in the commission's hands. Anyone want to kick it off? I'm perfectly comfortable accepting the recommendations of our Planning and Zoning Commission. I didn't quite get the understanding of why our staff didn't take a position on it. And according to you, they at first denied it, but then I guess when the Planning and Zoning Commission met, they kind of took a neutral position. Is that it? Yeah. So, but I'm willing to accept the recommendations of the Planning and Zoning Commission.
Mr. Chairman, I am as well, so I would make a motion to approve.
Perhaps the best motion might be to recommend approval, but table for additional findings of fact, conclusions of law, and we could determine what the status of the pathway would be.
Well, it was my understanding that staff was going to work with them on the sizes, keep it in place, but they would work with the applicant on terms of the exact criteria for the pathway, correct?
And you felt there was sufficient language in the recommendations of the Planning and Zoning Commission?
To do that, right? If you don't consider there's sufficient language, I would agree. We need to put that in there, but I thought, it was my understanding that the condition in the current proposal would allow that flexibility for staff to work with the applicant to do that.
Yeah, Chairman, Commissioner, I believe that's the case. However, I might recommend we reopen to allow Brent to show us that condition language and make sure everyone feels comfortable with it. Again, I think it's a generally,
I'm comfortable with it. I've read
generally
it.
enough
It's
written
already in
condition
the-
that we could do that, but yeah, so,
It's already in the file.
okay.
So
Yeah, so Mr. Chairman, Commissioners, if you're comfortable with that condition, findings are ready
Yeah.
based on the recommendation from the Planning and Zoning Commission for approval.
Okay, you making a motion?
Yeah, so I would move that we accept the approve the application 2023-00319 ZCDA MSP Hawkins Company Commercial Developers, based on the findings of fact and conclusions of law and the comments tonight.
Okay, is there a second to the motion?
I'll second that.
Okay, you've heard the motion. All in favor, say aye. Aye.
Aye.
Aye.
Motion carries. Okay, is there anything else need to be brought before the board tonight?
No, Mr. Chairman?
All right, then we're in adjournment. Thank you.